Thank you very much, sir, for the kind presentation. Although I have to admit, I'm not a doctor yet, just a colonel, and then I have a master's degree, but maybe someday. Thank you very much. And
I didn't know the meaning of this.
Okay, sure. You know, I was taught in the military that if you don't know the rank of someone, just go up. He'll never be offended. And thank you very much, all you early birds. I really appreciate all of you coming here to hear this presentation with all the temptations and the Sea of Galilee outside. I want to share with you some of my thoughts as a practitioner on the relationship between ethics and law. And well, these are two concepts having a complex relationship between them. And my three associations went to two other such concepts: love and marriage. Now, in Roman mythology, Venus, the goddess of love, was sweet and good-natured. Juno, the goddess of marriage, on the other hand, was a shrew. And the two goddesses were not good friends. So maybe love can be compared to ethics in the sense of being free and personal, while marriage, like law, is a social institution. We will get back to that soon, but first let us look at what ethics and law share. Both are systems of principles or rules aimed at directing human behavior. I think this is quite self-evident. Let's go now to what are the differences between ethics and law, and I'll try to do it brief. Law is formal, usually written, and there has a certain procedure to accept law, while ethics is more informal. Law is based on obligation or coercion, while ethics is based on expectation or voluntary. The legal question would be, what must I do? The ethical question is, what is the right thing to do? What should I do? Law is based on detailed rules, while ethics use open-ended principles. For instance, military ethics will say you have to treat humanly your enemy if you capture him. On the other hand, the legal rules would say exactly how should the quarters of prisoners of war look like, what kind of food do they have to get, clothing, medical attention, etc. Law is collective and centralized, while ethics is personal and decentralized. Law is based on sanctions, formal sanctions like fines and prison sentences, while ethics is based on informal sanctions such as disapproval, shame, self-guilt, etc. And law aims at minimum standard, the standard everyone has to stand to, while ethics strive to a high desired standard, not just the common denominator. So are professional codes of ethics law or ethics? This looks like a confusing question, but some of you may feel already that the differences just described are somewhat simplistic, especially when professional codes of ethics are concerned. They are written and formal, usually. They are often prescribing detailed rules. They are issued by an authority. The authority can be state-delegated authority or association-delegated authority, but it's not personal. It's based on authority. And it is accompanied by sanctions, suspension or removal from a professional association, or even loss of license to practice. So maybe the more accurate way to describe the relationship between law and ethics is looking on a continuum, having law on one extreme and personal ethics on the other. It is certainly less coercive, with less harsh punishment than criminal law. When the ethical code is enforced only through contract law, regulating association, then it is closer to contract law, or closer to personal ethics than torts, which is the involuntary branch of civil law. On the other hand, if the ethical code is backed by state-delegated disciplinary powers to suspend or cancel a license to practice, one may say it is actually closer to criminal law and more coercive than torts, which can only enforce pecuniary damage, or contract law, which is based on consent. And this is really the question that interests me. Law and ethics usually have areas of overlap, and it is understandable. For instance, it may be important from an ethical perspective to denounce to denounce as unethical even serious criminal offenses, like raping a patient, for instance. In these cases, the parallel norms do not compete. The ethical rule may have a complementary role to that of the legal rule, ensuring specific professional disapproval of that behavior above the level of general disapproval. However, the scale of the overlap may change. It can be like this, and it can be like this. In this presentation, I'm more interested in this area of ethics, the one that is not interfered by law. It is important to remember that this is a question of legitimacy, especially when ethical rules affect third parties. In a democracy, the legitimacy of law derives from public participation in regulating the relations in society, direct or indirect. In a similar way, rules of ethics which regulate the relationship within an association, like how you cut a deal in the diamond industry, for instance, you shake hands and say mazel and bracha, they have clear legitimacy. However, when is it legitimate to let a professional community to regulate its obligations towards the public? The public is not participating in the creation of the rules, and this creates a question of legitimacy. What you see before you is not an exhaustive list, just some criteria I thought of, and I'll be happy to hear ideas about other parameters that could be relevant to these relations. When should law withdraw and leave the ground for ethics? Now, a word about professional independence. The classical example is our lawyers, which at the core of their professions are confronting authorities on their clients' behalf. However, in certain circumstances, it is important to healthcare providers too, especially when they operate in institutions like prisons or the military. And I understand some of my colleagues in this panel will speak about these dilemmas. Terra incognita, professional ethics can be seen as a scouter, something like the Curiosity just landing on Mars and checking the ground before the more heavy law can come along. Notice that some of these parameters are general and relates to a certain profession, like the first one, while others are issue sensitive, like terra incognita, which means that we may leave some issues to professional ethics of a certain profession while intervening legally in other issues. Now, I will illustrate and test my suggested criteria on 4 cases, if time will allow. The first case I want to speak about are lobbyists in the parliament. Now, that's the story. Last February, an investigative TV show in Israel, Uvda, revealed some practices of lobbyists in the Israeli parliament, the Knesset. An investigator for the show registered to a training course for future lobbyists and used hidden camera to record some of the methods taught by one of the senior lobbyists. The senior lobbyist described how he convinced a member of Knesset to pass a law requiring drivers to have reflective vests in their cars. And he did it just to promote the business of a corporation he represented, 3M, which was stuck with a large inventory of this material in Israel. He spoke about drafting bills to be handed by a member of Knesset, influencing the information provided to the Knesset Research and Information Center, which is supposed to be objective, etc. The outcry after the broadcast caused the Knesset chairperson to limit lobbyist movement and entry to some parts of the Knesset, while some voices in the public debate called for the total removal of paid lobbyists from the Knesset. The claim was that they corrupt the system, act with lack of transparency, and represent big money against the public interest. Only then, under that threat, an association of lobbyists called Government Liaison, Kishrei Mimshal, was created and released in May a professional code of ethics drafted with the help of the Israel Democracy Institute. The code was accepted with much suspicion and cynicism. Why? Well, I'm going through my criteria. Is it a profession to be a lobbyist? Do we respect it as a profession the way we respect doctors or lawyers? Can we trust them to consider the public interest? Is there a positive social value in their work? And last and most important, does the timing of the drafting of the ethical code raise suspicion of ethical wash? I use the phrase ethical wash like greenwash to represent something which is not real. It has just the target of moving law away, saying we would regulate our obligations. And I think in this case, this was the paramount factor which caused the public reaction to this code of ethics. A second example I want to give. Combating terrorism, laws of war against military ethics. In recent years, it became clear that the ability to wage war to create an organized armed group able to conduct protracted campaign over wide territory is no longer a unique capability of states. There are no longer three guys, meeting in a basement and planning to plant a homemade bomb in a shopping mall. That's not the story. Non-state actors like Hamas in Gaza, Hezbollah in Lebanon, the Taliban in Afghanistan and Pakistan, or the FARC in Colombia, and others have military wings stronger than some small and medium regular armies are. On the other hand, many of these armed groups do not adhere to the laws of armed conflict. Furthermore, they abuse the law by using it as a weapon against adversaries who comply. Just a few examples. The fighters don't wear uniform and don't distinguish themselves from the civilian population. They shoot rockets from amidst the civilian population, placing it in danger. As seen in the upper picture, you can see showing a rocket launched by Hamas from the city of Gaza. And they aim many of their attacks against civilians in the other side, making it a tactic of terror, as seen as the photo below, where the outcomes of a rocket from Gaza hitting the Israeli city of Ashdod is depicted. On this background, some say that the laws of armed conflict that developed over the last centuries to regulate warfare between states do not fit the challenges of this asymmetric warfare. In 2004, an Israeli Major General, Amos Yadlin, working with Professor Asha Kasher, which is chair of ethics at Tel Aviv University, presented their suggestion to ethical principles for combating terror. Their suggestion, too, has encountered criticism in the public debate, especially after the Gaza operation in 2009, when some alleged that these principles were the source for an extreme policy of force protection on the expense of the risk to civilian population in Gaza. Actually, these principles were never adopted by the Israeli Defense Forces, although presented and discussed in the general staff. How can we explain this outcome using the criteria I suggested? Professional expertise. Now, one can argue that military expertise is just one of the relevant expertise in forming ethics in this field. However, the team working on these principles was mixed and included an esteemed civilian philosophy professor, so the problem is probably not here. Fairness towards third parties. The big question is how fair ethical principles created by the military can be towards enemy civilians. On the other hand, who has a moral right to demand soldiers to risk their life? There is an interesting interplay here between international perspective embodied in the laws of war and domestic perspective, although the aim of the authors of the ethical principles was to create something with a universal validity. Now, professional independence, that's not a parameter when military ethics is concerned. And I think here that's the crucial element, the terra incognita. The unique circumstances in warfare, the pressures and life-threatening situations, the need for split-second decisions, make it important that there will be clear rules and not vague principles. If you have vague principles, they kind of confuse, and this may be an explanation for the criticism of these ethical principles. Now I move to an issue probably more familiar to medical practitioners, the dilemma between keeping the patient's secret and reporting it in order to prevent harm from third parties. The most famous example is the landmark decision in the Tarasov case. The family of Tatiana Tarasov, seen in the picture here, sued the university employing the psychotherapist counseling her murderer, who was a student. The claim was that the patient was obsessed about Tatiana and told his therapist he wants to kill her, but the therapist failed from warning her or protecting her otherwise. The Supreme Court of California determined that indeed a therapist has a duty, not just toward his or her patient, but also towards the public. In some circumstances, the performance of this duty may demand the therapist to protect the third party by warning him, hospitalizing the patient, or taking other measures. This dilemma between patients' confidentiality and protecting third parties is not unique to psychotherapy. It raises questions in other fields of healthcare. For example, should a physician report a truck driver who has a drug problem to the proper authorities so they may consider to revoke his driver's license? What about a patient with a contagious disease and people who may be at risk for him? These are just a few examples. Should the guidance what to do in these cases be given by law or by professional ethics alone? Let us examine it using the criteria suggested. Unique professional knowledge, I think that's simple. Usually there's lots of respect for psychiatrists and psychologists and their professional knowledge. Fairness towards third parties. That's the 2 minutes. The dilemma the therapist has here requires him to consider the interest of other people, the patient and the third side. His self-interests are not directly involved. One may claim that he is somewhat inclined toward his patient interest, but considering the fact that trust in the therapeutic relationship was initially the reason the patient had confided his secret, is it that bad? So I think here we can answer in the positive too. Now, terra incognita, maybe in the 70s or 80s, that was another consideration to avoid legal intervention, where discourse about this dilemma seems to be new. Today, more than 35 years after the Tarasov ruling, the experience gained may give less weight to this argument. However, I still agree with the conclusion in my LLM thesis, not doctorates, done 15 years ago. In this issue, law should just give the general frame requiring a therapist to follow professional procedures in thoroughly considering all relevant circumstances before reaching a reasoned decision. Law should refrain from further intervention that will distort decision-making and cause harm to the overall public interest.
Another and last example is in the field of healthcare, but now another issue. The general profession-related consideration, of course, do not change, but let us see the impact of issue-related criteria. The 3.5-year-old girl you see in the photo is Natalie Borowski. In 2005, she entered a relatively simple operation to correct her squint. If you look carefully in the picture, you may notice it. She never awaked after the operation, and 3 days later she passed away. What happened? The anesthetist did not reduce the initial dosage given to the child as required. The dosage she gave the girl caused heart arrest, lack of oxygen, and finally death. Giving the wrong dosage is a mistake and may be negligent. However, that was not all. Court findings were that after the initial phase of the operation, the anesthetist went deliberately to sleep, not before she reduced the vocal alarm indication from the monitor. This was done although the anesthetist was required to follow the patient's condition throughout the operation. These last actions brought the district court and later the Supreme Court to find Dr. Lupu, the anesthetist, guilty of manslaughter, not negligence. In other words, the court found the anesthetist's behavior at least reckless and disregarding towards human life. She was sentenced to 8 years imprisonment. Later, her license to practice medicine was revoked. After the license was revoked, an esteemed professor of medicine published an op-ed titled "The Third Victim." Can you guess who the third victim is? The first is the patient, the second is the patient's family, and the third is the physician involved. The writer explained very convincingly why revoking a license from a negligent physician will endanger attempts to encourage healthcare providers to report openly medical mishaps in order to learn lessons and increase patient safety. The only problem was that the article ignored completely the factual findings in the court, that the anesthetist was not just negligence but acted in blunt disregard for human life. What does this tell us about the ability of the professional medical community to handle fairly these cases? In dealing with this issue, I want to make a distinction. The definition, where does what happened fits, is always the first phase. And here there is a distinction. When the distinction needed is between mistake and negligence, it needs some dialogue between the jurist and the physicians. But when it comes to finding of reckless or deliberate behavior, these are factual findings to be made by judges after a fair trial. But the second question, or after the definition of the situation, is what should be the response? What should be done? In here, if it's just a mistake, it should be left to the medical community. But if it's not merely a mistake, the legal system should decide. Here, the natural empathy toward fellow practitioners brings a tendency to close rank and makes it necessary for the law to intervene to ensure justice and fairness toward third parties.
So, I'm trying to show that professional ethics is often more law than ethics. When should law refrain from regulating professional conduct and leave it to professional ethics? An array of factors should be considered. Some professional related and some issue related, but all are time sensitive and can be changed over time with our experience. Thank you very much. I really appreciate your comments. I understand later maybe we'll have time for it.